day to everyone. Our topic for today is all about law on obligations, more specifically with the general provisions. Let's define first what is obligation. So, according to Article 1156, if we are going to define it, an obligation is a juridical necessity to give, to do, or not to do. So, we have 3 points here. The obligation is a juridical necessity. Aside from that, what kind of necessity? To give, to do, or not to do. Now, why is it called or is it phrased as juridical necessity? Because in case of non-compliance, you can actually file a court action. So, the that is juridical. So, we are referring to Article 1156 as civil obligation. Okay, so that it binds the other parties, wherein the other party is obliged to give, to do, or not to do. Now, every obligation has four definite elements, without which no obligation can exist. Now, we have active subject, passive, object or the prestation, and juridical or the legal time. Now, the active subject. Active subject is known as the obligee or creditor, or who has the power to demand the prestation. Therefore, he is the creditor. The creditor has the right to enforce the fulfillment of the obligation and the power to demand the prestation. Ano po yung prestation? The object of the obligation. Now, we have also another term which is passive subject, which is also known as debtor or obligor in other terms. Who is that obligor? He or she is bound to perform the prestation. Now, we already know the difference between the active and the passive subject. Aside from that, one of the elements of obligation is the object or prestation. What is that? That is the object or undertaking to give, to do, or not to do. Okay? So, we have different types of prestation. Okay, according sa sa definition ng obligation, to give, to do, and not to do. So, iba-iba po yung klase or sources ng object natin. When we say to give, it consists in the delivery of a movable or immovable thing in order to create a real right or for the use of the recipient for its simple possession or in order to return to its owner. Okay? So, for short, kapag ang prestation is to give, you have to deliver any movable or immovable thing. It could be real or personal property. But when we say to do, it refers to all kinds of work or services, whether mental or physical. Okay? So, yan po yung to do. It refers to services. You have to do it. And the active subject or the creditor has the right to demand for the fulfillment of those services. It's either mental or physical. And the debtor or the obligor is obliged to fulfill the obligation. And the last one, kind of prestation is not to do. When we say not to do, it consists of abstaining from some act. It includes not to give also from being negative obligation. So, mapapansin ninyo sa definition, to give at saka to do or not to do, walang not to give because not to give is also same with not to do. Okay? So, wag po tayong ma-confuse dyan. So, not to do, again, it consists of abstaining from the act. Wag mo siyang gagawin. Okay? So, ayan. So, we have requisites for this prestation. Hindi lang dapat na kahit ano lang magiging object na ng obligation. It must be physically or juridically possible. Kasi kapag impossible po yan, hindi po siya magiging valid. Magiging void po siya kasi nga ang object is impossible to fulfill. We have also determinable or determinate as to or according to a pre-established elements or criteria. So it has the capacity to be determined or determinable among the objects. We have also possible equivalent in money. Okay? So pecuniary interest need not to be one of the parties. It may be for the benefit of the third persons distinct from the parties to the contract. And prestation need not be of economic character to have pecuniary value. So if it does not have value, the law attributes to it economic value, example, moral and nominal damages. Now, that's for the rules or requisites of prestation. But yung tatandaan natin dito, it must be physically or juridically possible, and it must be licit and determinable, or at least determinable according to its pre-established elements of criteria. So, dapat natin yan tatandaan. And the last element is the juridical or legal tie. When we say juridical or legal tie, it is also called the vinculum juris, which binds the contracting parties. The juridical tie or vinculum juris is based on the sources of the obligation arising from either law or contract. Okay, so you heard it right. Ito pong efficient cost natin, or sometimes tinatawag siyang efficient cost, juridical tie, legal tie, or vinculum juris. Dami niyang term, no? Okay, so ito yung nagbabind sa contracting parties, the debtor and the creditor. Without it, there can be no civil obligation. Therefore, this juridical tie is the sources of the obligation. And actually, there are two sources of obligation only. We have the law and the contract. Okay? So, when we say law, example niyan, relation of a husband and wife, giving rise to the obligation to support the children. Pag mga bilateral acts naman, contracts giving rise to the obligations stipulated therein kapag contract. Ayan. Let's continue the kinds of obligation according to the subject matter. Actually, na-discuss ko na siya kanina with regards to the kinds of prestation. So, we have real obligation, or otherwise known as obligation to give. Now, okay, if babalikan natin yung discussion natin kanina, it consists of delivery of what? Movable and immovable thing in order to create a real right or for the use of a recipient for its simple possession or in order to return to its owner. So that's obligation to give. Now, we have also personal obligation, and personal obligation, ang scope niya is obligation to do or not to do. So here we have positive personal obligation and we have negative personal obligation. Now, sa positive personal obligation, that's obligation to do. It refers to all kinds of work or services, whether mental or physical. But we have negative personal obligation, which is the obligation not to do, which consists of abstaining from some act, which also includes not to give, being negative obligations. Now, punta tayo dito sa sources ng obligation. We have law, contracts, quasi-contracts, acts or omissions punishable by law, and quasi delics. Begin with the law. So, obligations derived from law are not presumed. Okay, so only those expressly determined in the code or in special laws are demandable and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen by the provision of the book. So law is, example niyan is the obligation to pay taxes. So they are not presumed, diba? That's in accordance with law, and ignorance of the law excuses no one from the compliance therewith. So um, you cannot deny that you do not know the law and you will not pay the tax kasi hindi mo naman alam yung batas. So, ignorance of the law excuses no one. So, kapag mga obligations na nga that arises from the law, so we have to obey that. Okay, so example niyan is obligation to pay taxes. And from the family code, the father is obligated to support his children. Okay, so if ganon. Ayan, so the law is governed by the law itself. And the agreement of the parties is not necessary here. Okay? So, hindi kailangan mag-agree si BIR at saka yung taxpayer for the tax collection. Okay? And again, law is not presumed. Okay? Only those expressly provided are enforceable. Okay? So, let us proceed to contracts. When we say contracts, The obligations arising from contracts has the force of law between the contracting parties and should be complied in good faith. So, when we say contracts, it's a meeting of minds between two persons, whereby the party binds himself with respect to the other to give something or to render some service. So, meron siyang contract dito, okay, the other party, to give something, okay, or to render some service, who bind with the other party. So, may meeting of minds sila, meaning may consensus. And, all the agreements na na-stipulate ng both contracting parties must be complied in good faith. Okay? So, ayan. So, we have two types only of sources of obligation, the law and the contracts. Now, what happened to the quasi-contract, quasi-delic, and delic, sir? So, actually, the quasi-contract, delics, and quasi-delics are types or part na ng contract. Okay? So, law and contracts lang talaga generally. And quasi-contract, quasi-delic, and delics are part of the contracts. Okay? But they are still sources of the obligation. So, we have here quasi-contract. Okay? So, sa quasi-contract na to, no one shall be unjustly enriched, okay, or himself at the expense of the other. Now, the two common forms of quasi-contract are what? We have solutio indebiti and negotiorium gestio. So again, in quasi-contracts, obligation that derive from this source of obligation shall be subject to the provisions of Chapter 1, Title 7. Okay, so it requires that certain lawful, voluntary, and unilateral acts gives rise to the juridical relation of quasi-contract to the end that no one shall be unjustly enriched. Okay, wala dapat maging unjustly enriched, okay, benefited at the expense of the other. Okay, so lawful siya, voluntary, and unilateral acts, meaning voluntary siyang ginawa ng isang party na um, hindi naman siya kumuha ng consent with the other party to do that act. Unilateral siya, hindi siya in-induce ng other person to do that. Okay, kasi nga voluntary. So, hindi siya contract, kundi parang kontrata na siya. Kasi ano yung reason? No one shall be unjustly enriched at the expense of the other. Example, solutio indebiti. Okay? So, solutio indebiti is payment by mistake. So, whoever's receive any payments which exceeds, okay, ayan, naka-receive ka pero hindi mo naman talaga yun pagmamayari. So, you have the obligation to return it to the owner. Kasi nga, sabi ng quasi-contract, no one shall be unjustly enriched at the expense of the other. So, parang naging contract mo siya ngayon. What is the contract? For you to return the payment, okay, which is made by mistake. We have also negotiorium gestio or officious management. So whoever voluntarily takes charge of the agency or management of the business or property of another without any power from the latter. So meaning, nag-voluntarily take charge siya sa property ng iba without gaining consent from that party. So, tama yung sinabi kanina sa quasi-contract na it refers to voluntary unilateral acts. Okay? So, same with this, negotiorium gestio. So, wala siyang authority, pero binolunteer niya na siya yung magmamanage from that time. Okay? So, ano yung magiging obligation ngayon ng may-ari? Sa nag-volunteer na mag-manage ng property. So, he is obliged to continue the same until the termination of the affair and its incidents, or to require the person concerned to substitute him if the owner is in the position to do so. So, this relation does not arise either at these instances. First is when the property or business is not neglected or abandoned. So, kailangan abandon siya. Okay, and if, in fact, the manager has been tacitly authorized by the owner. Ngayon, ang tatandaan kasi natin dito sa negotiatorium gestio, voluntary unilateral acts, meaning hindi siya kumuha ng consent from the other party na i-voluntarily take charge na yung property, abandon property. Okay? So, ayan. So, if ever, binigyan or humingi siya ng consent doon sa may-ari, hindi na yan negotiatorium gestio, kundi implied contract of agency na po yan. Kasi nga humingi siya ng consent. So, dapat dito, ang element sa negotiatorium gestio, para maging quasi-contract to, is dapat walang consent from the other party or the owner. So, meaning, any expenses borne by the officious manager who voluntarily takes charge of the abandoned property, he shall be reimbursed by his expenses out of that property management. So, yan yung magiging liability ngayon ng owner. Okay? Kasi ano nga yung magiging principle natin sa quasi-contract? No one shall be unjustly enriched at the expense of the other. Okay? So, let's proceed with the Quasi Delic. Now, Quasi Delic is also known as culpa achilleana. It is an act or omission which causes damage to another, thereby being fault or negligence, and there being no pre-existing contractual relations between the parties. So, if ma-observe ninyo sa definition niya, there is an act or omission. When we say, ang na-omit dyan is the ordinary care or diligence of a good father of a family. So, in the obligation kasi, when you are obliged to give something or to render some service, you are obliged to take good care of the thing with the proper diligence of a good father of a family. Ano ang ibig sabihin yan, sir? You are obliged to put ordinary care. Unless na lang if there is a stipulation that requires another standard of care. Okay? So, if nawala yung diligence na yun of a good father of family or the ordinary care, you are now negligent. Okay? May negligence ka doon. So, may nag-cause siya ng damage to another, pero in this quasi-delic kasi, wala kayong pre-existing contractual relation. Meaning, wala kayong existing contract. Nangyari lang talaga siya because of an incident, and ano yung naging source or naging dahilan ng incident? Omission of ordinary care. Okay? At yung omission of ordinary care, nag-cause siya ng damage sa other parties. Okay, so that's quasi-delic. Don't worry, we will give a further explanation when we go beyond the topic. And the last one is delicts. Delicts or felonies are acts or omissions punishable by law. So in here, example, the obligation to pay medical bills of the mauling victim by the person guilty of physical injuries. So ayan. Okay, so crimes na yan punishable by the law. Okay, so you have also the obligation to support the child delivered by a rape victim, by the rapist. Okay, or father. Halimbawa, ni-rape siya. So, that's a crime. So, may obligation ka ngayon to support that child. That's the consequence. Okay, so that's delicts or acts or omissions punishable by law. So, you have here a civil obligation from criminal offense, which shall be governed by the penal laws. So there you have it, the 5 sources of obligation, or the 2, okay, I will correct myself, the 2 sources of obligation, the law and the contracts, and contracts has quasi-contract, quasi-delicts, and delicts. So we have here crimes. So when we say crime, it is committed and has a material damage that is caused by virtue thereof, and there is a civil liability that arise, and this is when an obligation is created. Now, civil liability arising from crimes or delicts is governed by the Revised Penal Code and the Civil Code. So we have here different forms of civil liability. So we have restitution, reparation, and indemnification for consequential damages. So when we say restitution, the thing itself shall be restored. So it happens wherein the obligor shall return the object of the crime. So we have here an example. A committed theft against B. So, kapag ninakaw mo yan, in that case, A will have to return to B what he stole. So, that's restitution sa ulian, or the thing itself must be restored. Okay? So, next one is reparation. When we say reparation of the damage caused, the court will determine the amount of the damage. So, this happens when the obligor will have to pay for the damage caused. Example, A rape B. Since the object of the crime may not be returned, okay, the guilty party shall be obliged to pay reparation of the damage caused, pegged at 100,000 pesos by the court. So kung mapapansin nyo dito, the court determines the amount of damage. That is reparation of damages caused. And we have the last one, indemnification for consequential damages. In here, this is not only caused by the third party but also to those suffered by his family or third person by the reason of the crime. So this happens when a guilty party will have to pay for other damages suffered as a consequence of the crime. So for us to understand, we have here an example. A stabbed B multiple times, but due to the immediate medical attention, B was able to survive from the incident. So due to the wrongdoing, the obligor or yung may kasalanan is obliged to pay for the actual expenses, okay, be incurred for the treatment and for other damages brought about by the stabbing. Hindi lang yung medical expenses, kundi yung mga lost income, if example, employee yun, di ba? So, yun, i-include din yun, okay, as part of the indemnification for consequential damages. So there you have it, the three forms of civil liability and its corresponding concept. We have here the difference between a crime and a quasi delic, kasi most of the nag-aaral ng obligations and contracts, akala nila same lang yung crime at saka quasi delic, where in fact magkaiba po silang dalawa. So when we say crime, there is a criminal or malicious intent, so may intention talaga of the criminal negligence, while this quasi delic, there is only negligence. When we say negligence, the omission of the care or the ordinary care. Ano nga yung other term ng ordinary care natin? Diligence of a good father of a family. So, na-omit yung proper diligence. Kaya nangyari, okay, so ang tawag dyan, quasi-delic. So, in crime, the purpose is punishment. While sa quasi-delic, ang purpose is to indemnify the offended party. Kung ano man yung damages na na-cause, plus yung consequential damages, yun yung babayaran ng party at fault. Okay? So, in crime, it affects public interest, while quasi-delic only affects private interest. Sa crime naman, may dalawang liabilities, criminal and civil liability, while in quasi-delic, there is only civil liability. Okay? So, ayun. In crime, criminal liability cannot be compromised or settled by the parties themselves. So, hindi nila pwedeng isettle na lang kasi we have laws na dapat susundin or magiging basis of the consequence. While in quasi-delic, the liability for this can be compromised just like any other civil liability. So, it could be settled by the parties themselves. Okay? So, in crime, the guilt of the accused must be proven beyond the reasonable doubt, while quasi-delic, the fault or negligence need only to be proved by the preponderance of the evidence. So, magkaiba po yung dalawa, the crime and the quasi-delic. So, there you have it, the general provisions of the law of obligations. So, see you next meeting for our next video tutorial.